So wait, the losing side in a Supreme Court case still releases an opinion? What do we do with that? I mean, it was a 5-4 decision. What does the decision from the other side mean? Well, I will tell you. Let's take a look at the Supreme Court and how we deal with what are called plurality decisions. I'm Brian. I make videos about law and civics. Please comment, like, share, repost, all the stuff. Get this video out there. This is information we all need. So share this so other people will see it. Okay, let's look at the Supreme Court. Supreme Court, 9 people. Now, if all 9 of them agree on the outcome and all 9 of them agree on the opinion, then one of them will write the opinion. That opinion will say at the top, opinion of the court delivered by Justice number 1. And that entire opinion will become binding on the lower courts. And the reality is that happens more often than we hear about, but those aren't the really exciting ones, right? So what happens if just one justice disagrees? If they all agree on the opinion, then that opinion will still be binding on the lower courts, and the opinion written by Judge number 9 will be called a dissenting opinion. This opinion will start, the opinion of the court was delivered by Justice number 1, with Justices number 2, 3, 4, 5, 6, 7, 8 concurring. That means 2 through 8 agreed to the opinion. And then it will say Justice number 9 dissenting, and it will have Justice number 9's opinion. Now, Justice number 9's opinion is not binding on lower courts, but it's not nothing. Like the dicta that I talked about in my other video, sometimes the Supreme Court likes to go off script and ramble a little. And those ramblings may not be binding on the lower courts, but they may be instructive to the lower courts. If someday a set of facts comes up where the thing talked about in number 9 is super relevant and nothing talked about in the rest of this is there, this might convince a judge. Sometimes a dissenting opinion will work for you in court. Now, what happens if we have a more split opinion? We're used to these sorts of opinions these days. 5 on one side, 4 on the other. And if all 5 of these guys agree to the reason why, then they'll all share this one opinion. Once again, it will say, opinion of the court delivered by Justice 1, Justices 2 through 5 concurring. And because 5 of them agree, this will be binding on the lower courts. Let's say that all of the dissenters also agree on their opinion. Once again, it will say Justice 6 dissenting, Justices 7 through 9 joining. Now this, still not law. But once again, just like this one, it might come up someday, and this might be way more convincing in court than that was. If 4 of them agreed, that's not a bad argument. Not to mention, if 5 years from now, Justice 5 has retired and been replaced by somebody who tends to agree with 6 through 9, you've got a pretty strong argument. But there's another thing that happens a lot, and that is when these groups of justices still don't agree. And as an example, I'm going to bring up the Cruzan case, which is a famous case about the right to die. And I'm not going to get into the specifics of the opinion, just who decided what. But here's the important part. In Cruzan, Justice Rehnquist gave the opinion of the court, which meant that 4 other justices agreed with him on that opinion. And that decision was binding on the lower courts. But 2 of the justices who agreed with him had some ideas of their own. Justice O'Connor agreed with him, but had her own ideas. At the beginning of Justice O'Connor's opinion, it said Justice O'Connor concurring, which means she agrees with the main opinion, but has her own thoughts as well. And Justice Scalia also had a concurring opinion. Because these 2 justices agreed on this opinion, it becomes binding on the lower courts. But their opinions are only as binding as this one. They're just suggestions. Now, on the other side, Justice Brennan wrote a dissent, and Justices Marshall and Blackmun agreed to that dissent. But Justice Stevens wrote his own dissent because he also disagreed with this, but for completely his own reasons. Both of these opinions are dissenting opinions. This one has a little bit more weight than this one because 3 people agreed to it. But what's really crazy is that even though these 2 agree with the main opinion, they also don't have a lot more weight than this one. In fact, this one might have more weight because 3 people agreed to it. But that's kind of tough to say. I might make that argument sometimes, but I'm not guaranteed to win. Betting on a dissent is always a little risky. Now there's one last thing just to make this as complex as possible, and that is the plurality opinion. In a plurality opinion, 5 people agree on the final answer, but nobody agrees as to why. So they got the 5 votes on their side, but not an agreement on the opinion. And plurality opinions are kind of a mess. There's a whole body of law for how plurality opinions have to be interpreted by lower courts. and it is messy. But we can get into that someday. Now you understand the basic framework, though, and by reading the names at the top, you can tell whether this is a full-throated endorsement of the entire court or just part of the court. And you'll know what to do with those opinions that maybe have only the partial support of the court or no support of the court. All right, guys, hope this was interesting. Thanks for watching. Again, please share this and get this out there so people will see it. Let me know what you think in the comments. Thanks, guys.